Okay. Judge Shapiro, I'm seeing that the court reporter is here, so I can bring everybody in when you're ready.
All right, I'm ready. So make sure we get the video. Yeah. Okay.
Judge Shapiro, can you call the case before you start talking about it? Because
Yes,
look into my notes. I don't know what case is this. It just.
Oh, you're right. I'm kind of new to this. Thank you. Yeah.
And you know, I don't know if you don't call the case, I don't know if you're just talking casually, if you're ready to go on the record. That's kind of to me to go on the record when you call the case.
All right. Thank you. Thank you for the feedback. We are on the record. I'm calling the case of Mothering Justice v. Dana Nessel, case number, Court of Claims number 21-95MM. Why don't you both put your appearances on the record, or all three of you, and then we'll proceed.
Good morning, Your Honor. Deputy Solicitor General Ann Sherman on behalf of Defendant Attorney General Dana Nessel.
Good morning, Your Honor. Assistant Solicitor General Linus Bang-Hartlin, also on behalf of Defendant Dana Nessel.
Good morning, Your Honor. Mark Brewer of Goodman Acker on behalf of plaintiffs.
All right. Well, we have two motions before us today. One is a long pending motion for summary disposition, and the other is this recently filed motion to hold scheduling order in abeyance. I suspect we should address the summary disposition first, since the outcome of that may affect what we're going to do with the scheduling order. The argument will first go to the defendant. I'm just going to tell you up front, though, after reading the materials, my inclination is to grant the motion as to count one, but to deny the motion as to counts 2 and 3. So I'm open-minded. I'm prepared to change those views, but I wanted to let you know where I'm at, and so you can focus your arguments. So, Ms. Sherman or Mr. Bang-Hartlin, who's going to take the argument?
I will, Your Honor. Thank you. May it please the court. On the C8 motion, this would be a simple deck action or an action for declaratory injunctive relief if properly pled, but it has been unnecessarily complicated and not viable because the gravamen of the complaint is the alleged harm caused by an attorney general opinion rendered in advance of litigation and attorney general decisions surrounding that opinion, rather than the gravamen being the constitutionality of state laws. I do agree with Your Honor's inclination that count 1 under all circumstances should be dismissed with prejudice. And the reason for that is that there can be no actual controversy based on the attorney general opinion or decisions surrounding it. There's no causal connection between the attorney general decision not to rescind or supersede and the alleged harm here. If an attorney general opinion is concluding that a state law is unconstitutional, our courts have been clear that that opinion is not binding on a state agency. And if an attorney general opinion concludes that state law is constitutional, it's really the duly enacted law itself that is governing the enforcement conduct, not the attorney general opinion. And plaintiffs don't understand this because they wrongly state in the complaint that the state of Michigan is enforcing PAs 368 and 369 pursuant to the attorney general opinion. So I want to turn to counts 2 and 3. The problem with count 2 is that plaintiffs have intertwined the allegations about the harm caused by the attorney general opinion into count 2. And they have said specifically, and I'm quoting, this is from the complaint, paragraphs 25 and 26, that the attorney general as a result of Nessel's refusal to supersede or withdraw the opinion, hundreds of thousands of Michigan workers have been denied either the wages or the sick leave. They also claim that Nessel illegally and unconstitutionally has blocked these raises and paid time. They say that the Attorney General opinion has allowed 368 and 369 to be enforced. That's paragraph 9, paragraphs 25, 26, paragraph 1. The whole gravamen of the complaint revolves around the harm caused by an Attorney General opinion. And that's the problem with keeping count 2 in. I think count 2 could be dismissed without prejudice, and plaintiffs could refile it properly without intertwining those allegations. And frankly, it should be brought against the state of Michigan. On count 3, it's our position that plaintiffs can't get.
Yeah, there certainly have been cases challenging the constitutionality of a statute, which would name the AG as the relevant party. Why would that matter here?
Well, first of all, I would say I've not read any case where the allegations of the complaint have somehow tied the injury of this law to the Attorney General opinion. But I think
get that part.
So apart from that, what plaintiffs say in their complaint is that the Attorney General is bound to somehow defend this law in this lawsuit as it's pled. And they cite to MCL 14.28 and 14.29. And if you turn to those statutes, there's nothing in those statutes that requires the Attorney General to defend in a lawsuit that is brought in this court by private parties. Turning to MCL 14.29, which is the plaintiff's cite for that, both 14.28 and 14.29. 14.29 puts a duty on the Attorney General at the request of specific parties, and that's the governor, the secretary, the treasurer, or the auditor general, to prosecute and defend all suits. And if you look at section 14.28, the Attorney General shall prosecute and defend all actions in the Supreme Court. So I don't see that there is a particular, the Attorney General isn't bound to have to defend as this is postured. I agree with Your Honor that there are cases where that has been done, and the Attorney General has, not related to an Attorney General opinion, but simply on the constitutionality of the law. The Attorney General has not sought to get out of that litigation, but I think plaintiffs are incorrect in saying that the Attorney General must somehow defend. And that's why I think the best posture here is to dismiss count 1 with prejudice, to dismiss counts 2 and 3 without prejudice, and have them refile against the state where they can also get injunctive relief, because on count 3, they can't get injunctive relief against the Attorney General. She's not the enforcement arm here. She's taken no enforcement action. She wouldn't necessarily be taking enforcement action here. So I don't think count 3 would be viable as against the Attorney General. I think if plaintiffs' end game here is to challenge state law, then that's the way to posture the case. Dismiss count 1 with prejudice because there's no actual controversy. Dismiss counts 2 and 3 without prejudice. Allow them to refile properly. Name the state.
Who's gonna defend it?
Well, if the state is named, then, or perhaps if an agency is named, then they come to the Attorney General. The Attorney General can make the decision whether to defend that state law, and typically the Attorney General would. But plaintiffs are incorrect in saying that based on the posturing here where they are bringing the action, that 14.28 or 14.29 mandates that by the plain language of those statutes.
Okay. Okay, if I go to Mr. Brewer now?
Absolutely. Thank you, Your Honor.
Yep. All right, Mr. Brewer.
Thank you, Your Honor. I mean, the whole basis of this motion to dismiss is that the Attorney General says she agrees with the plaintiffs personally. That's fine. But she is the Attorney General of the state of Michigan. She's a proper party here under the unanimous case law of this state, under the court rules and under the Court of Claims Act. And just because her personal beliefs lead her in a different direction, that doesn't absolve her of her obligation to defend this statute. And as we pointed out in our brief, and as this Attorney General, like Attorney Generals before her, has done, the solution here is to split her office, not to further stall this lawsuit, which has now been pending for a year, because the Attorney General says, well, I agree with the plaintiffs. Fine, split your office, assign a group of attorneys general to defend the statutes, and then create another part of the office in which you can join the plaintiffs. We welcome it. And as I indicated in our brief, it's a mystery to us why the Attorney General has taken this so personally and why she has refused to proceed down that path. The Attorney General doesn't cite a single case that supports their position here. And the cases are legion, that when there is a dispute over whether an Attorney General's opinion is correct, you sue the Attorney General. The cases are also legion, that if there's a question of the constitutionality of state law or the interpretation of state law, that the proper party to sue, and exclusively so, if that's the desire of the plaintiffs, is the Attorney General. You know,
Why can't you sue the state of Michigan?
We
Why
could,
can't you?
but the court rules allow us, you know, they specifically say that if you have a case against the state, you can sue a state officer. That's in the court rule that we cite in our brief, Your Honor. I can give you the cite to that. Yeah, 2.201C5.
2.201.
2.201C5.
Okay.
It specifically says a party may bring an action against the state in its own name or in the name of an officer authorized to sue or be sued in its behalf. That is the Attorney General, and that has been the Attorney General for decades. Your Honor, if you're inclined to dismiss count one related to the Attorney General opinion, that's fine. We can live with that. But we'd ask that the other counts be allowed to proceed and there be no further delay in this action. I would also add that beyond all of the arguments in our brief, why this motion lacks merit, this is really about joinder of parties. And the court rules are also clear that misjoinder of parties is not grounds for dismissal. If the court orders us to add other parties, we'll be glad to do so. But misjoinder of parties, which is essentially what the Attorney General is claiming here, is not a basis to dismiss this lawsuit and to force it to start all over again after over a year of delay based on this motion. So we would ask that the motion to dismiss be denied, Your Honor, and that we'll be allowed to proceed. I'm prepared to file a motion on the merits, summary disposition on the merits within 2 weeks, so we can get this case moving to ultimately where it's going to go, which is probably the Michigan Supreme Court. And we can stop these procedural games because the Attorney General says, I don't want to be sued. Well, that's part of her job, is to be a defendant in lawsuits just like this. And there are mechanisms to deal with that without dismissing this case.
If the Attorney General were to split their office, is there anything that this court would have to do to permit that?
What's happened in the past, Your Honor, is that we would agree to a stipulated order that would allow her to intervene as a plaintiff. And, you know, if that order is agreeable to the court, as it has been in the past, done. She's intervened as a plaintiff, and another part of her office defends those 4 laws. And we can move on.
All right, Ms. Sherman, any rebuttal?
Yes, Judge. If this court is inclined to dismiss count 1 with prejudice, but to keep in counts 1 and 2, the AG would gladly stipulate to substitute the state of Michigan, and then plaintiffs could bring both a declaratory action and injunctive relief against the state because it can't get injunctive relief under count 3 as to the Attorney General. And with this court's permission, our office would be very amenable in that situation to having 2 teams, one on each side of the constitutional issue. We've done that many times in the past. We'd be happy to do that again. I do have concerns, however, with keeping in counts 2 and 3 and keeping in that language in the Attorney General in the complaint that is tracing injury to the Attorney General opinion. And that is what my concern is here, which is why we have said we think the best course of action is to dismiss all counts, definitely count 1 with prejudice. Counts 2 and 3 could be dismissed without prejudice and refile, crafting this properly so they aren't tied to some injury by the Attorney General opinion or the Attorney General opinion process. That language, those allegations are very, very damaging. When you're talking about an Attorney General who somehow has allegedly illegally and unconstitutionally blocked some kind of action, when it was the legislature who itself passed a law and the AG is not enforcing that against some state entity, it's very damaging. But if this court chooses to leave in counts 2 and 3, we think the best course of action is to substitute the state of Michigan, and then we'd be happy to have 2 teams from our office.
Well, let's say we were to, Mr. Brewer was to amend to add or substitute in the state of Michigan. How would that delay this case?
I don't think it would delay this case at all. I think we're ready to go. We are ready to brief it as well. And certainly it wouldn't take us any time at all to get 2 teams together. We actually have that conflict wall in place because we were anticipating after the adopt and amend case in front of the Michigan Supreme Court that there would be a properly pled case. We have the conflict wall in place. So I don't think it would cause any delay at all to substitute the state of Michigan and then to have 2 teams from our office. And we're happy to make that happen quickly.
All right. Mr. Brewer, without asking you to reveal any litigation strategy, what's the problem with just substituting in the state of Michigan, changing some, removing the apparently offensive allegations and getting this case to an SD motion?
Well, Your Honor, first of all, we'd be happy to add the state, but not to dismiss the Attorney General. That is contrary to the case law of this state, to the court rules and the statutes. But we'd be glad to add the state or add a state agency. The Attorney General herself, in the case she brought in federal court, sued the Attorney General and the governor over the same-sex marriage statute. We'd be glad to proceed down the same path here and add another defendant, be it the state of Michigan, be it Lara, be it whatever. That resolves that problem.
For reasons I don't fully understand, I'm not sure that they're legal reasons, but the Attorney General is not pleased with the allegations concerning her. Is there any reason not to strike those if what we're going to be doing is proceeding with a straightforward constitutional challenge as against the state and or the Attorney General?
Look, the Attorney General, in her answer, when she files one, can deny those allegations. Those allegations lay out the case as my client sees them. And there's been no dispute as to what has happened in this case, in the history of this case, as laid out in her complaint. So the Attorney General can deny them, and we will focus on the legal issues in this case. There are no disputes of material fact here. The Attorney General may not like what was said in the complaint. That's pretty common among defendants, Your Honor. You know that. Defendants always dislike what is alleged in a complaint. Let's move on. Grant the motion if you desire as to count 1, deny it as to counts 2 and 3. I will get a summary disposition motion filed forthwith. If the court would like me to add a defendant, fine, we'll do that, and we can get this case moving at long last.
All right. Well, thank you all very much. And we still have the other motion pending. We'll issue an order, but I'm going to dismiss with prejudice count 1. I'm going to deny the motion to dismiss counts 2 and 3, but direct that the plaintiff submit an amended complaint adding the state of Michigan as a defendant. If in fact, as has been discussed here, the parties believe that the splitting of the AG's office to address both sides of the issue was proper. If you'll submit a stipulation, I'll be happy to sign that. And otherwise, I'll be looking forward to SD motions. Is that clear to everybody?
Yes, Your
Yes,
Honor.
Your Honor.
Yes, Your Honor, would you like to set a deadline for those motions?
Well, let's see what's on the scheduling order as we speak. SD motions are presently not due till December, so I suspect that either of you object to setting a deadline. What is it now? It's the middle of March for like the end of April?
That's fine, Your Honor.
That's fine, Your Honor.
Okay. All right, so SD motions to be filed by April 29th.
Your Honor, if I could just,
Pardon me, sir?
thank
All
you,
right.
Your Honor. I just want to be clear before we go.
Thank
You would like me to add the state of Michigan as a defendant? I'm just making notes here.
Oh, yeah, you're right. And I don't know, will the state of Michigan will have to answer at that point. Will there be a problem, Ms. Sherman, regarding getting the SD motions filed, given the time the state has to answer?
I don't believe so, Your Honor.
Okay, very good.
Could I clarify, when you've asked the plaintiffs to submit an amended complaint, would that amended complaint still allow plaintiffs to keep in the allegations tied to the Attorney General opinion? Because then I do think that there is an issue of standing with respect to count 2. Because there is an actual, they haven't created an actual controversy with respect to the Attorney General opinion.
Okay. Mr. Brewer, you want to respond to that?
Your Honor, as we laid out in our complaint and in our brief, there's no question that the parties are adverse as to the AG opinion. The Attorney General has refused to rescind it. She's refused to supersede it. We've made very clear that we disagree with it. And either directly or as a byproduct of this litigation, we think that opinion should be overturned when the statutes enacted in December of 2018 are declared unconstitutional, we hope ultimately by a court. So again, I'm mystified by all of this. The defendant can deny whatever allegations they want in our amended complaint. Let's move on and stop with the stalling of this case.
All right, well, I'm not going to make
May I just respond on a legal point?
Pardon?
May I respond on a legal point?
At this point, but
Is the reason that there's not an actual controversy here with respect to the Attorney General opinion, even as to count 2, is that nothing related to the opinion 7306 or decisions regarding that opinion would do anything to guide plaintiffs' future conduct in order to preserve their legal rights. And that's the definition of an actual controversy. So here,
Okay.
an attorney, I had strong reservations. Thank you.
You tell me if this is doable or not, because I'm new to this game. So count 1, so the new complaint should not contain count 1.
Yes, Your Honor.
And I think it should indicate somewhere that the Attorney General is being named solely because she is the law enforcement officer of the state of Michigan, and not for any reason having to do with the whether or not the AG opinions were right, wrong, or should have been rewritten.
Thank you, Your Honor.
Thank you, Your Honor. We'll do that.
Okay, very good. So given that, I'm going to deny the motion to hold the scheduling order in abeyance. I suspect that was to prompt me to realize there was a case here. We'll get an order out, and I hope everybody can be as prompt as they've indicated. It's an interesting issue. I look forward to it.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you all. Does anyone wish to order this transcript?
Yes, defendants would. Defendant Nessel would.
Not right now, Your Honor. Thank you.
All right, very good. Thank you all. Then we'll conclude this.
Judge Shapiro,
Thank you, Your Honor.
stay online.
Thank you.
Because I have a problem signing back in. That's what took me so long last time. Are we using the same link for the next hearing?
I apologize, ma'am. I didn't hear you, and I'll come a little closer.
I was wondering if I could just not, keep online instead of being, having to sign on again for the next hearing.
Well, the next hearing is not until 1 o'clock, but it doesn't matter to me. I don't know about our person who manages this. I imagine she's on the line. I really don't know.
Okay, all right, thank you.
All right. Thank you. Bye-bye.